Good evening, everyone. It's Thursday, December 8th. This is the Hingham Historic Districts Commission. I'd like to call the meeting to order. We have one item on the agenda for this evening. It's a continuation, 66 School Street. Matt Falconieri is here with Richard Henderson and Sally Weston. So if you want to come up and grab a seat, that'd be great. For the audience, thank you for coming. Appreciate it. I'm glad we have a fan club here. How we're going to work this is we'll start off with the applicant. You guys can lead in and talk about whatever you'd like to talk about, and then I'll open it up to the audience if there are any questions, comments. Please feel free. If you do speak and want to make a comment, just state who you are and your address. And if you could limit your comments to the demolition of this house. That's what we're focused on tonight. And then after that, we'll deliberate with the commission. And I will ask the applicant if you want to come back with some questions, direct them towards me as a follow-up. And if there are any follow-up questions from the audience, you can direct them towards me too after that, okay? And then hopefully we'll get to a vote tonight. This is the third meeting, so I think I think we need to get to some type of conclusion here on this. So, all right.
Chairman, do you want to do this?
Yeah, let's.
Now or
thank
later?
you. So we have 4 voting members here tonight. It's Dennis, Lois, myself, and Virginia. We have Mike Collardi, who was here before for the last couple meetings, is not here. So I thought what we do is, Ben has been here for all the meetings, as Chuck has also. So I thought what we do is we draw a name from the hat there, and whoever comes up is going to be the voting member. Is that okay? So we'll make it 5.
Does that work for you?
I have no objection to the procedure. So.
Yeah, just to, we usually have 5 voting members, and I think we should do that.
All right, so what I did was I put Chuck's name in and Ben's name in, and then there are 2 dummy papers. So if you pull
Suggesting?
no, I'm saying,
And whose names are on those?
if you pull an X, it's just an X, because I thought it's hard to kind of mix things up when they're.
That's
it's
true.
only if it's an X, you gotta pick another one. Oh, yeah. X. Okay. Check it is.
All right. Okay, and with that,
Open letters, just.
Richard, do you wanna start, or?
Sure. Yeah, that's
Matt,
fine. No, I can go
however
ahead.
you wanna do it.
I'll set out because I wanted to kind of want to explain what I've been doing for the last month, what I found, and how I'm going to treat this case. There are 2 aspects of it that I'll deal with tonight. One is the simple merits of whether or not this is entitled to a certificate of appropriateness, for which I am convinced beyond any case I've worked on a long time that it is. And there are some procedural issues that I want to address, which are of great concern to me, and I'll talk about those probably in a minute. But before I do either, let me just go through the facts on which I based my conclusions on just the merits of the case, and I'll just reiterate what we probably already know, that it's a 66 School Street, which is the subject of this application. It's for a certificate of appropriateness, not only to raise the property, but to reconstruct a gambrel house that Sally's plans have depicted, and you have with your application. It's a 1941 house with a rear addition in 1979. It consists of 20,588 square feet of land, and it's purported to be in the Phase 2 extension of the Hingham Historic District. On file with the Historic Commission is a Form B, which I'll leave with you later. I'm sure you all have it. The Form B describes it as a Cape Cod revival. There is no other historical or architectural information appended to the Form B with respect to this particular property. As you know, in August of 2007, the appropriate town agencies prepared and had published a report entitled the Hingham Center Historic District Phase 2 Extension Preliminary Report, and I believe one member had that with him the other evening when we were here. The report contained a number of findings and conclusions about this particular part of town, and specifically, I found 4 or 5 quotes because I tried to find something to address 66 School Street or this part of the neighborhood. The introductory part has this quote that the proposed extension includes a total of 70 homes, 64 of which are contributing structures. Many were built by Cushings, Lorings, Southers, excuse me, another Cohasset name, Lanes, Ripleys, and Levitts, just to name a few. There's no mention in the report as to which of the 6 properties of the 7 were non-contributory, and there's no reference to 66 School Street on the Form B to any of the names identified in that preceding quote. So those were the only names mentioned as historically significant. Not that they're the only ones, but there's no reference to any of them in our Form B. Under the report, there's a section, Roman numeral number 5, which is considered significance of the district. And I've also annexed just those pages to this report. In the second page, it highlights the importance of the area around Levitt Street and East Street as being the center of agricultural and horticultural part of the community. It makes no reference in that section whatsoever to School Street. The third paragraph of that section says that the ball field along Spring and School Street, which is the first mention of School Street, was, along with the adjacent common area, an integral part of the town's defense system for early settlers. And it goes on to conclude that the area is an extension of the common and the special role it played in our town's history. 66 School Street is neither butts the old ball field or the common area, is several houses away from these significant areas, and was constructed several years after the historical events for which this area is identified cannot be seen from the property. The ensuing paragraph provides again, School Street's mentioned. On the corner of Spring and School Street, bordering the training fields, is a cluster of 3 antique houses, 2 capes of Federalist, with a typified character, feel of mostly 19th century neighborhood. Again, 66 School Street is not mentioned. It is 3 or 4 houses away from Pleasant Street, and was constructed in the mid-20th century, not the 19th century, and adds no historical significance in the area identified in this paragraph. It's not referred to, or is that section of School Street. Paragraph 6 of Section 5 says of the 70 properties included in Phase 2, 64 are contributing, as I mentioned earlier. 12 homes were built in the 1700s, 25 in the 1800s, and 27 in the early mid-1900s. The 6 non-contributing homes are described as revival style, complementing the historic character. It's interesting to note, if you look at our Form B with respect to 66 School Street, it defines it as a Cape Cod revival. It is not unreasonable to assume that the houses defined as the revival are the ones that are considered non-contributing. At the time of the proceedings, earlier proceedings, there wasn't any evidence offered, although I inquired as to the historical and architectural significance of this property. There was none offered with regard to historical events, architectural value, site significant events on the property, or as to the color or texture or appearance of this property. There was no evidence. A structural engineer on behalf of the applicant testified that the structure as it exists and its foundation do not lend themselves to improvement, and found that neither had the structural stability to sustain the kind of renovation that was suggested or any other kind of renovation. And I've resubmitted that engineering report. I know that you engaged your own consultants, but your own consultants didn't say anything. They didn't file any reports, they didn't appear, and we have no idea what their position is, but we have nothing that we can work with or refute that would suggest that that our structural engineer was incorrect. The report is there, and we're relying on that. And finally, there is in the whole volume, I just referred to the Phase 2 preliminary report, a plan entitled a Phase 2 District Plan, which is in the booklet, but it is not at the Registry of Deeds. And so before I get to the merits of the case, let me tell you the other thing that I did, and I wish I'd done this before I went to all the trouble, As I looked at the procedural background of the the Hingham Historic District, having worked on these for other towns to see different events, when amendments occurred and so forth. And as you know, Section 3 of Chapter 40C allows municipalities to adopt historic districts. It also allows them to modify, to alter, to increase, and to reduce them. Section 3 is very long, but it concludes with the following paragraph. It says, "No ordinance or bylaw creating an historic district or changing the boundaries of an historic district shall become effective until a map or maps setting forth the boundaries of the historic district or the change in the boundaries thereof has been filed with a city clerk or town clerk and has been recorded with the Registry of Deeds for the county or district in which the city or town is located." In going through my research for this, I read a lot of material on file at the Registry of Deeds with regard to the Hingham Historic District and other aspects of your historical preservation. But what I didn't find was any plan that complied with the statute. I've had 3 different law firms now follow up, and none of them all of them can confirm to me independently and without conferring with each other that there is no plan with regard to this Phase 2 on file with the Plymouth County Registry of Deeds. So I'd like to read one more time that sentence: "No ordinance or bylaw creating an historic district or changing the boundaries of an historic district, this was the case, shall become effective until a map or maps setting forth the boundaries of the historic district or changing the boundaries thereof has been filed with the city or town clerk and has been recorded in the Registry of Deeds for the county or district in which the county or town is located." There's nothing mysterious about this language. It's been confirmed. This is not how I want to end up with this case, but this district is not effective until that plan is recorded. The statute is clear, it's unequivocal. There can be no mistake that the failure to record the plan is a significant and irreparable mistake with respect to the existing application. Anyone who buys a home, the people who buy homes in historic district don't all come from Hingham. They come from Brooklyn, New York, and Los Angeles, California. And the whole reason the statute requires the district plan to be recorded is if the plan's not there, your home is encumbered or burdened by something you would not know. And so it's not a minor technical part of the statute. It's an compelling part of the statute to protect the general public. The word effective is not a mystery. It means that when you get it on record, you have a district. If you don't, you don't, even if it's been 7 or 8 years. And I don't attribute that misdeed to anyone here. None of you probably had anything to do with this committee in 2007. And I'm not sure it's the responsibility of a commission to be dealing with its procedural and technical aspects. That's a town government responsibility that exceeds your responsibility, but it does affect your ability to function properly. I went on and I wanted to make sure that in reaching this conclusion, which is not what I was looking for, that the language cannot be more clear. No ordinance or bylaw creating a district or changing the district shall become effective until a plan is recorded. There's really nothing confusing about it. It precisely and clearly requires the recording of a plan before the district becomes effective. Notwithstanding compliance with all other statutory requisites, the recording of the plan is the mandatory to the district in order for the district to exist. I went through a bunch of cases involving statutory construction, and there's a concept in statutory construction called the plain rule doctrine. Means that the plain meaning doctrine, if something says something and anybody can understand it, there's no way to get around it. It's binding and it's enforceable. I cited a U.S. Supreme Court case which got nothing to do with zoning. It's just a leading case in the plain rule doctrine, and the case was it Falconieri versus the United States. It was decided by the Supreme Court 100 years ago. And it says, where the language is plain and admits of no more than one meaning, the duty of interpretation does not arise, and the rules which are aids to doubtful meaning need not be discussed. If something says what it means what it says. And I cited 2 other mass cases, the same thing. The conclusion is clear that I don't think there is jurisdiction over this phase of the historic district until you properly comply with the statute. And that isn't how I wanted to come to this. This isn't the answer I was looking for. I was looking for other material. But assume for the moment, even if I'm wrong, the other thing I want to refer to is Section 7, which Mr. King referred to when we were here last week. And Section 7, in its pertinent part, says that the commission in reviewing a request for a certificate of appropriateness shall consider, among other things, the historic and architectural value and significance of the site, the building or structure, the general design, the arrangement, texture, material, and color features involved, and the relation of such features to similar features of buildings and structures in the surrounding area. As I said earlier, the Section 5 part of the Phase 2 report has not identified anything of significance with respect to 66 School Street, nor does the Form B relating to 66 School Street have appended thereto any historical or architectural commentary. At the hearings, no information, evidence, or reports were advanced by anyone on behalf of the commission that would indicate anything significant occurred at the site, or that improvements on the property have been either historical or architectural significance. And I reiterate, I know that the experts you consulted were with regard to structural, not with regard to historical and architectural, but they never filed a report, they never offered any evidence. So I can only assume that they didn't have any to offer, or else something would have been forthcoming. The Phase 2 report frequently talks about mid-19th century features of this area of Hingham. Very little, if any, reference to the things occurring in the 20th century. I found one reference to the 20th century. The report also defines properties as non-contributing properties and identifies them as revival properties. The Form B, as I mentioned earlier, with this submittal of this memo in dealing with 66 School Street indicates that the improvements on 66 School Street are, in fact, of the one of the revival properties. And I'm assuming that you have to consider that that's one of the houses that the authors had in mind when they wrote the report. There are probably more than 6 referred to as revival properties, but this is clearly one of the 6. I tried to find cases that could help me because I didn't really have any evidence I could put my teeth into to refute. So I found a case, a recent case actually, a 2005 appeals court case entitled Warner versus Lexington Historic District. In that case, the appeals court was reviewing a Superior Court decision concerning the accuracy of a decision by a Historic District Commission, actually the Lexington Commission. And the court concluded that you, as a district, must apply a standard of review analogous to the governing exercise of the power to grant ordinary special permits, taken from the zoning context. And in the case of a denial of an application for a certificate of appropriateness, the commission is required to notify the applicant in writing as to the reasons, and this is the key language, and it cannot paraphrase the statutory language without containing within the explanation how those statutory factors bear on the denial of the certificate and the reasons and effect. I didn't come to the first hearing, but I've been to this we haven't offered it, but I came to the second hearing. There was, in fact, no facts before this commission that could sustain a basis for denial. I didn't hear anything. I heard colloquial stories about the Mason cottages in Cambridge and people thinking that the house was unique in some way, but that's not what the statute's about. It's about preserving historic and architectural features or sites or an impact on places. And there are no facts that would satisfy the Warner case. And I found another case that's not quite on point, but it's a Harrison case, which is a Cape Cod case in the old Regional Historic District in Cape Cod. And then, as in zoning cases, the court said substantial deference ought to be afforded to the determination of appropriateness or lack thereof by the commission. However, the discretion of the town and the town committee is not without bounds. And in that case, the court overturned the commission's denial of a certificate of appropriateness because it was unable to determine any rational basis for the commission's decision. The rational basis, again, has to tie into Section 7. There has to be evidence of its historic significance, its architectural significance, its site significance, or something about the texture, the construction that blends with the neighborhood. None of that was offered. So I would say, even without the procedural defects, a case has been made that this is entitled to a certificate of appropriateness. I'm happy to answer any questions.
Okay, thank you. Why don't we open it up to the audience first, and then we'll start our discussion on this end, okay? Unless, Matt, you have anything else, or Sally? Good, okay. Any questions from the audience?
I'm just here, I'm 62 School Street,
Yeah.
Kitchen Bates, and I just want to say I'm totally in support of Matt's proposal. I I loved Bill, who lived in the house. Had a nice long chat with Andrea today, and my feeling is, if Bill was in the house, I wouldn't touch it, obviously. But it's a mediocre house, you know, as somebody once said, you don't want mediocre judges on the Supreme Court. A mediocre house really shouldn't qualify as a historic landmark. That's all I have.
Our company, I live at 34 Mill Street. I guess my comments would be along the same line. You know, I go up and down that street and around the corner on Pleasant Street and Middle Street, and there are some beautiful, lovely homes. We're a historic town. We have a very high inventory of homes from the 1800s, even some from the 1700s. I get that those homes are historically significant, and I am a full supporter of doing whatever we can to preserve that part of our town. I don't understand a 1941 ranch-style cape. If anything, it sticks out on the street as not belonging to me. All the other houses, for the most part, are these beautiful historical homes. So I just don't understand it. And I listened to what the attorney has said, and that there's no facts being presented to explain why it's a historic home. And it just makes it really hard, as someone who lives in this town and wants to preserve the historic nature, how this decision can be being made, other than just based on some personal opinion about the streetscape and how it fits. It just seems like there should be something more solid there as to why we're trying to save this home.
May I speak about two other quick things? One is, I also, you have a comprehensive historical report of the community. It's about 150 pages at the Plymouth Registry. And it talked about this period as being a period of revival from the 20s to the early 40s. And one of the principal type of revival homes during that period was the Gambrel Colonial, which is exactly what is being proposed, consistent with this report. That's coincidental, but it's helpful for our case. It wasn't, I don't know if you planned it that way or not. The second thing is that Matthew lives in this neighborhood. He has to look at this home. He's part of that community. He obviously doesn't want something in his neighborhood that is not consistent with the community, the neighborhood, and the historic aspect of this neighborhood. So those are other facts that I think you need to take into consideration.
Okay. Any other comments from the audience? Okay. All right. Since there was so much procedural and legal discussion, Dennis, I thought maybe we'd start with you on kind of your take on what you heard tonight and what your views on all this is.
Okay. First of all, thank you for your presentation. It was very helpful. Council is correct, in terms of statutory interpretation, that to be read in accordance with the plain and ordinary meaning of the words. It's the first time we've been presented with that language on this particular project. Obviously, if council is correct, then we do not have jurisdiction, and this district is not effective. So it seems to me that there are two things that can be done in that regard. Either this matter can be continued and that fact can be determined to be true or not true by town council, or we can act on it despite the open question, in which case I guess one of two things happens. They appeal it, and if they are correct, they prevail on appeal. On that basis alone, even assuming that council is not correct on that point, I remain troubled by the state of the record before us, and by that I mean this. There was reference made to this report last time about, I think by you, Hans, language in the report talking about some structures reflecting the evolution of a neighborhood and the like. Okay, I accept that. But I think we have to think about that a little bit more. That cannot mean that any structure ever constructed in a historical district, which would, as a matter of fact, reflect evolution of the district, is protected under the statute. I mean, if we were talking about an 8-foot by 8-foot cinder block structure with a flat metal roof, we wouldn't be having this discussion. So that gets me to the next question, which is, what is it about this particular structure that warrants protection under the statute, given the guidelines that we have? I haven't heard anything yet, which is why I said what I said at the last meeting, that based on what is before us, I didn't see any grounds for denying the application. And I think on the state of the record before us, if they appeal, even on the substance, I think there's a distinct possibility that they could prevail, unless I'm missing something, and I'm open to hear what everybody else has to say about the historical significance of this particular structure. But I look at the statute, which tells us that we should not make any recommendation or requirement except for the purpose of preventing developments incongruous to the historic aspects or architectural characteristics of the surroundings in the historic district. And I haven't heard anything yet that would allow me to deny the application based on any reason that falls within the scope of that language.
All right, appreciate it, thank you. So, Richard, last time you talked about getting us a brief or a memorandum so we could go through it and look at it. Since there's a procedural technicality here, it would have been great from a commission standpoint if we could have gotten that ahead of time so we could look at it and we can answer all these questions and clear it up. So you put us in a position that's kind of out of our jurisdiction and beyond our bounds here.
And let me say, not intentionally, my whole focus was on going through, there's a ton of stuff there, but in going through the registry, it became apparent to me at the last minute, which changed the thrust of everything I was doing. Well, it didn't change it, it meant more work in a different direction, which I only as recently as today got the third opinion from another title company.
Yeah. So I don't think that's for us to decide as a commission. I think we are here to decide on the demolition of 66 School Street and the merits of the application that's before us. As far as a technicality, I think that's something that the town or another body needs to decide. So that's my view.
Okay, that's fine.
Can I just add something on that score, Hans? I guess I would take issue with one thing. I don't, if this is correct, I don't view it as a technicality. If this is correct, we don't have the authority to act. And I think town council could, I suspect, in very short order, by talking to whatever lawyers have done this title search, determine whether that is or is not true.
But Dennis, this is being sprung on us right
No, I
here.
understand that.
And you actually emailed all of us if we could get a memorandum ahead of time.
Absolutely.
And we did reach out, nothing was there, so I think this is kind of, hold on. I think this is kind of being sprung on us tonight, which I think is not what we're trying to get at.
I don't disagree. I'm just trying to think in terms of trying to minimize the potential expense to the town of an appeal if it could be short-circuited.
Let's let the town handle that.
Okay.
Okay?
Doesn't this really have ramifications for projects that have passed through this
Sure does.
previously?
Yeah, I
Sure
mean,
does.
this is beyond the scope of this commission and what we've been doing since I've been on it. So I think some other parties.
Yeah,
might
I mean, I'm not suggesting that we should determine this. We're not competent to determine it.
Question then is, when should that happen? Should we go forward in consideration of this application, or should we wait
Okay.
to hear what the issue is from the town's point of view?
I mean, you got a serious delay here that you're looking at. I think, in my view, I think we should make a decision based on what we have in front of us in terms of the merits of the property and the application. And I think a decision should be made, based on what we decide. That's my view. There could be something that's been filed that, has maybe been overlooked, I'm not sure. There could be something that covers what you're looking for. I don't know.
I can only rely on the three people I rely on and leave it at that. With the greatest respect to, no one has reached out to me about anything. I've not talked to a member of this commission or anybody else since I was here the last time. And again, I would have filed this if I hadn't gotten railroaded into not railroaded, but sidetracked into some other part of this, so.
Andrew, you have reached out, correct?
I mentioned it to you.
You mentioned it to me this week, and I said we were working on it. And as
Right.
Richard said, we weren't expecting to find that.
Let's not get
It's
bogged
really
down.
not.
Let's not get bogged down in this. So I think there's a lot of questions here about the historical nature of this home, and let's see if I can shed a little bit of light on it. I can tell you this is probably this is the most important application that I've seen since I've been on the commission. I think it's really important that we get it right. I've seen 300 applications since I've been doing this, and I can tell you this one is really crucial to get it right. So let me just give you a little bit of history here. This house was built and lived in by William and True Hodges in 1941. The couple married in 1938 and lived in Hartford before moving to Hingham. They had one son named William. The family moved to Hingham because William received a position as an airplane supplies tester at the ammunition depot. So Virginia was talking about this last time, and she's actually right about that. So there was this gentleman, William, was working at the ammunition depot. He is a descendant of James Whitten, one of the first settlers who came to Hingham in 1647. Other families that lived in the house worked in local organizations such as the ammunition depot and the public school system. 66 School Street is a simple Cape-style home with one story. It was built coming out of the Great Depression and leading to World War II. Money was scarce, and people were mostly concerned about putting a roof over their heads. It's important to note that families that lived in this house made significant contributions to the war effort, the town, and local organizations. The house has stood on School Street for 75 years and contributes greatly to the streetscape, in my opinion. School Street and the Hingham Center Historic District exhibit significant diversity with homes built between the 1700s to the present day. With its simple design and features, 66 School Street represents an important period of U.S. and town history. It represents how the street and the town evolved, from a farming community to industrialization to the post-war period to the town's current expansion led by the financial and other growth industries. To demolish this house permanently takes away an important component of the School Street streetscape, an important element of how the town evolved. There is no dispute that this home is historic. It's 75 years old. Anything older than 50 years is considered antique. Massachusetts Historic Commission considers anything over 50 years as historic. In the 1800s, if townspeople decided to demolish homes that were 75 years old, we wouldn't have much left of this town right now. There's been a lot of debate about whether this home is a contributor or a non-contributor to the district, and I heard Richard talk about that earlier. It's 75 years old and it does contribute. What is being proposed is certainly a non-contributing home to the district. Andrea did some work today, and the homes that are non-contributing out of the 70 that you mentioned are the follows. 84 Levitt Street, 86 Levitt Street, 138 Levitt Street,
One what?
138 Levitt, 152 Levitt, 153 Levitt, 155 Levitt, and 1 Village Lane.
Rolling here.
All these homes were built between 1961 and 1989. There's nothing wrong with this house. We've had 2 well-known builders and reputable restoration experts go through the house. It is structurally sound. I know what your engineer said. what he said in his letter was correct. However, it is structurally sound, it can be lived in, it's lived in right now. It can be worked with. How does this home and its proposed demolition fit within our guidelines? From why Hingham has historic districts in our, on the website and our bylaws. By maintaining the architectural quality of a neighborhood, an historic district creates a continuing sense of the past. It provides a framework for preserving distinctive features that form a visible record of our forebears' way of life. The charm of Hingham's historic streetscapes combines authenticity of features, variety of designs, and evolution of styles. While many buildings within a district may well have unusual merit on their own, even a modest property can hold such interest if it is recognized as a symbol of product of events and patterns in community history. In that sense, the establishment of an historic district creates a whole that is greater than its parts. I'm going to read to you the functions of the Hingham Historic Districts, and these are 3 of them. To preserve the unique characteristics of properties and structures within an area of historic interest. I think taking this property down is not a preservation of any of this property or structure, so definitely goes against that. To maintain and improve the settings of those structures. By taking this down, I don't think this is an improvement, and I don't think this is maintenance. And lastly, to promote community awareness of Hingham's architectural and historic heritage. I think we're getting away from that by demolishing this house. From guidelines for work within Hingham Historic Districts, demolitions. Demolitions should be contemplated with great caution, since they are irreversibly alter an historic building, its site, and the neighborhood. Less drastic alternatives may be available. I think some of those things we've talked about in previous meetings. From Article 28, Historic Districts Bylaws, Section 1, the purpose of the bylaw is to promote the educational, cultural, economic, general welfare of the public through the preservation and protection of the distinctive characteristics of buildings and places significant in the history of the town, or its architecture, and through the maintenance and improvement of settings for such buildings and places and encouragement of design compatible therewith. I think we heard that earlier. I think preservation and protection is a key component that's being violated here. From Section 5, factors considered by the Commission in making determinations for applications for certificate. In passing on matters before it, the Commission shall consider, among other things, the historic and architectural value and significance of the site, building, and structure. I think I've laid that out for you in terms of its historic significance and value. So, you know, there's 6,216 single-family homes in Hingham. 720 of them are within the districts, and that's our jurisdiction. They're protected under Secretary of Interior, Massachusetts General Law, and town bylaws. There's plenty of opportunity to work outside the Hingham Historic Districts. We have conveyed that putting a one-story addition to the rear, perhaps adding a 2-car detached garage to the rear of the property, would be very appropriate for this home. Other minor restoration work would certainly enhance this home's value. I've stated since the first meeting that I can't vote in favor of the demolition of this house or this application. I believe I would be doing the town a disservice by approving this demolition. I hope the applicant will consider these comments and other remarks from the Commission. Thank you.
Just out of curiosity, is that someone's report, or is that just your notes? In other words, I guess I'm asking, where did the information in that come from?
Our archivist did some research.
Okay, I would just say that in the same way that a memorandum would have been helpful to have before the meeting, that might have been helpful.
Because I was under the opinion there was no evidence. And I have 3 comments.
Oh, hold on a second. I want to just have the other members of the Commission speak if they can, and then we'll give you a
Excuse me
chance
for
to.
interrupting.
And you have a chance. Lois?
Yes.
Virginia? Please.
I'll only read this one.
Okay, that's fine.
I'm sorry.
No, that's, you did it.
One thing I want to bring up is something I learned while I was preparing. And I would say, in defense of our committee, sometimes we're given a project and it takes us time to research it. You came in with, your project, and we're volunteers. It takes some home time to go through some of these things. And one of the interesting things I found out is there's a difference between the word historic and historical, which I had always, same thing. Historic means there's an event, a person, something that has a name to it, like Pearl Harbor has a name to it. And maybe you brought up some names. I didn't consider this house historic. Betsy Ross didn't do the flag in the house. But it is historical because historical refers to a piece of time, and a period of time, a series of events, but no one thing is attached to the house. And what I wanted you to hear was something that I found in the bulletin number 22. And what's the name of it?
Is it preservation briefs?
National Park Service. That I felt really applied to this house. And I felt it applied because in the 1940s, we had the shipyard doing the building. We had the Naval Ammunition Depot over at Bear Cove. We had Wampatuck, which was actually called the Cohasset Annex at the time. And in driving up Fort Hill Street, there are 5 other little houses just like this house that lead me to think that there could be others in different parts of the town. So I went into this brief, and I found this, and I think it would be better if I just read this paragraph, because I don't want to take a word out and make it mean differently. The 1966 National Historic Preservation Act did not assume that significance could be a matter of rigid objective measurement. It specifically encourages the recognition of locally significant historic resources that, by appearance or association with persons or events, provide communities with a sense of past and place. The historic value of these resources will always be a combined matter of public sentiment and rigorous, yet necessarily subjective, professional assessment. And I felt that really applied to this when I looked at some of the other parts of what was going on in Hingham at that period of time.
Good.
Well, to cut to the chase, I favor rehabilitation over demolition because I think that it's 1941, but I think that Hingham needs to be responsive to ongoing history, not only colonial history, and Hingham was important to the war effort, and as came out tonight, the owner of this house played a significant part in that effort. I think, therefore, rehabilitation, because of that importance, even though it's a very simple house, is warranted. And even though, as Hans said, the whole is greater than the parts in a historic district, each property needs to be recognized as a physical record of its time, place, and use. And I think that's another added value to retaining this property.
At first, I was torn by this whole thing, and hearing some of the discussion tonight from you with regard to the validity of this district, I'm still somewhat torn by things. But in general, I must say, I tend to favor saving this house, because, as has been said by others, this is part of the history of the town. It's not just simply, since it's not colonial or 19th century, we basically scuttlebutt it. I think it's an important part of the history, visual. And the fact that it doesn't exactly match other homes on this street does not mean we tear it down. I think we learn to incorporate it into the streetscape, which I think is very important.
Based on what was been discussed tonight, my opinion hasn't changed from the last, which is some of those homes that have already been torn down. I'm not in favor of tearing it down, but if I were a voting member, I would approve the request.
Richard, you had some questions, and I'll get to the audience if they've got any thoughts.
No, one of the things you reiterated in your report what your experts said, but that's totally unacceptable evidence. They weren't here. If they had something to say, they should have said it here and not secondhand. So I don't think it's really appropriate what your consultant said, and I think it's totally irrelevant to any ultimate decision here. Secondly, every single house in Hingham has some significance for the Second World War. The entire community worked at the shipyard. That doesn't come within the scope of the statute. There's nothing in the statute that allows you to use that as a basis for denying someone their legal rights. You can't find a house in Hingham that existed after 1930 that someone from the war effort didn't live there. I mean, there were thousands of people who worked here. It was huge. This house has absolutely no connection with the shipyard or with the war effort than any other house where people live. You can't deny somebody their legal rights because you think it might have some connection. And that is, the emphasis there is that you think. That's just not an appropriate basis for denying a certificate of appropriateness. But I mean, honestly, I was trying to find a way to make this easier for everybody. It's not going to be easy because I'm not sure you should even be sitting here. And so if you think denying a certificate of appropriateness is the way to go, there's nothing I can do about it, but the remedy for me is not the appropriate appeal to this. It's a declaratory relief in the nature of mandamus, ordering a building permit to be issued, which is a very simple thing to do, and that's what I'm going to have to do. I don't want to do that. I would just soon see you grant Matt his relief and find a way to solve the other problem with your town council. That's what I would think is the simplest thing to do. I think the implications for the board are not good. I mean, I don't know how many District 2 cases you've had over the years, but I think you would not want to, I think you'd want to face the problem head on, but it's just, I still haven't heard anything based on the Warren case that substantiates a denial. I'm sorry. Speculation is not a basis for a legal conclusion.
Okay, thank you.
My own preference on this would be, given, before people go filing lawsuits in a town, having to respond to lawsuits, if it were up to me, if the applicant were willing, I'd kick this over to our next meeting and let town council determine whether it's an issue or not.
I'd be happy to submit a memo to Susan.
It just seems to me that it will be a lot of wasted effort if at the end of the day, they're correct. But I'm only one member.
I hear what you're saying. I tend to concur with you.
I think it's,
That's agreeable.
thank you.
Okay. Any other questions from the audience?
Tom Coburn, 34 Middle Street. You cited a couple engineers walking through the house. Do you have the names of the engineers who went through the house?
Yes. I do. Peter Bickford.
Mr. Chairman, they are general contractors. They are not engineers.
Right. And we also had
Wilcox.
Ben Wilcox.
Don't, excuse me, Mr. Chairman, don't these two specialize in historic homes as well?
But reciting the names of expert witnesses who did not testify is not a very healthy way to try facts.
Any other questions from the audience? Okay, what does the commission feel we should do at this point? I've heard from Dennis, I've heard from Chuck, I've heard from Lois. Do you wanna push this back, or do you wanna take a vote?
You know, I concur with finding out the legality of it.
I'm much more comfortable with going that route.
Okay, that's what we'll do. Do we need a continuation on this at this point, this application?
We have,
How much time is left?
Actually, yeah, Matt, you'll have to sign another extension because this is only good until the 15th of January. And so, if you wanna stop by, I can type one up and get it ready. Because our next meeting is on the 19th,
December?
January.
Oh, good.
So, Richard, you will send a memorandum
Yeah,
to.
I have, I never got to where I was going with this. I did, the memo I just finished because I just got the final information on the title stuff and I didn't want to release it without it. I had a call as late as 2:30 today with a confirmation from another firm, so I can leave this. There was information added tonight, so I may supplement this by the 19th, but I'm happy to leave what I've done so far. Yeah. And there's 7 copies here, so I'll leave it, Andy, you can distribute it. The U.S. Supreme Court case I did because it was in an article, it was the leading case on the plain meeting rule, and when I used it in a zoning case, the zoning board chairman called me and asked me why I was using a case in human trafficking to deal with a zoning issue. The point is, it's not the thrust of the case, it's the Supreme Court's statement of the plain meeting rule that makes it a leading case. So if you decide to read it, you'll get the drift of why it's there.
There's plenty of Massachusetts law on that.
Yeah, no, I did, I just took that case because it was in a journal on the leading case, of the early cases on the plain meeting rule, that's all.
Dennis, will you take the lead on this to make sure from our end that we're doing all the work from a town standpoint?
Sure,
to,
as long as
to-
someone gives me the town council name and number, I'm happy to.
So
I can
I'm-
do that, Dennis.
So we're gonna leave you in charge with that on our end, and,
I assume you use Susan Murphy, correct?
Yes.
Okay, that's fine.
all right, good.
She's our real estate counsel.
Okay, thank you for coming, guys.
Good night.
Do we have any other business to take care of?
No.
I noticed a mistake, the word federalist came out as federalist.
Oh. Thank you.
I will stop when I can, and I won't file it on the 19th. I'll wait to see where we're going. But
Thank
thank
you.
you very much for your time.
That's great, thank you.
That troubles me, procedural.
Okay, at this point in time, I'd like to conclude the Hingham Historic Districts Commission meeting for tonight. Thank you all for coming. Do I have a second?
Second.
Okay, great. All in favor?
Aye.
Opposed? Good. Thank you.